Hello and welcome to Legal Basics with Cyril Law Global, and my name is Sian. We're still on the employment law series, and today we're going to discuss the disciplinary process at the workplace. You know, from the word disciplinary, you probably imagine that already something has gone wrong, someone has misbehaved somewhere. And to us today is a colleague of mine that I'm very pleased to do this with, and I will let him introduce himself.
Thank you, Sian. Hello, viewers. My name is Mugambi Mutwa. I'm an advocate. I practice at Hamilton, Harrison and Matthews at Mombasa. It's a pleasure to be here to have this discussion with you.
Thank you. We'll give you your tea later. But now, just take us through, how does the disciplinary process start? What needs to have happened for an employer to kick off the disciplinary process?
One word: conflict. By our very human nature, we are prone to conflicts. You have conflicts with yourself?
Sure.
And whenever there are two people involved in any particular setting or in any particular relationship, there is bound to be conflict. So how do we address this conflict without getting to each other's throats? So the disciplinary process has in mind the resolution of disputes at the workplace.
Okay. All right. So now let's say that an employee has done something, either their performance is not up to par. This is a reason for a disciplinary process, right? Or if they have done, maybe they've been absent, maybe they got into a fight, whatever it is. What is the right process for an employer to go through to ensure that they're on the right side of the law?
Thank you, Sian. When there's conflict, the easiest the solution to any conflict is to try to solve it. Now, a conflict can arise, as you've said, due to a variety of reasons. There can be someone who is coming to work intoxicated. There can be someone who has stolen at the workplace. Someone can fight with their fellow employee. Someone can abuse their superiors. Many other reasons. So how do you go about resolving this? The first step is, it starts from the management, who is the employer. Okay. The employer has to notify the employee that there is a conflict here. And the conflict is through writing to the employee rather, a show cause letter. You inform the employer informs the employee that there is this particular conflict that has arisen, and you would like to hear your explanation as to why this is so. Written explanation. Okay. So in the show cause letter, the employee should be informed what is the conflict about. Okay. That is what we say, what is the charge, and the particulars of that charge. And he is told that we require to hear from you in writing within so many number of days. So once the employee receives that notice, the employee can elect to write back to the employer, or he can just elect to do away with that and ask for an oral setup where they can come and explain whatever is happening. Now, let's consider the first option, where the employee replies to the employer in writing, detailing or answering the issues that have been brought forth in the show cause letter. Once the employer receives the explanation and goes through it, and he is satisfied with the explanation that has been given, that marks the end. Right. As soon as it started. If the employer is happy with the explanation, that's the end of the matter. Okay. But if the employer still has questions or is dissatisfied with the explanation given by the employer writes back to the employee and tells him or her that we are not happy with this explanation. Now, at this juncture, the employer has the right to ask for further explanation, or to say that we would like to accord you an oral hearing where you come and explain to us, or we hear your story. Okay. Now, this is now the process where the step where the dispute or the process has escalated to a disciplinary hearing. Right. Now, in this letter, the employer has to inform the employee once more, this is the charge. We would like to hear you on this particular date at this particular time. Now, some of the rights of an employee at this point, the employee, apart from being informed of the issue or the issue in conflict and the time of the hearing, the employee has a right to be given access to all materials that he requires from the employer.
Okay.
If the employer has these materials or this evidence that the employee wishes to rely on, he should be allowed access to it. This is due to the acknowledgement that in an employment relationship, the person who has the duty to keep employment records is the employer. Okay. The employee also has a right to be informed of their right to bring a witness to the disciplinary process. He also has a right, if you're a member of a union, to have your union or representative present during the hearing.
Okay.
Most importantly, you have to be given ample time to prepare for yourself. I would say that it would be unreasonable for an employer to inform the employee that they are required to attend maybe a disciplinary hearing in the next 1 hour. I don't think whether it meets the threshold. I would say 2 or 3 days would be sufficient for the employee to prepare themselves. Now, at the date of the hearing,
Okay.
let's have in mind the basic tenets of natural justice. Before you make a decision, you have to hear someone, give someone a right or an opportunity to explain their situation to you. Now, let's also bear in mind that we do not expect, or natural justice frowns upon, the person who is complaining to be the person who is hearing a case and to be the person who is deciding. Sure. Because obviously there will be bias. Yes. But now in an employment setup, you do not have a luxury of having many staff. Yeah. Most times the employer will be the complainant. Sure. And the employer is the person who is ultimately going to make a decision. So it's let's say a special relationship where the requirement of a person being the one to prosecute, the complainant, and the decision maker somehow has to be ignored. Okay. Where circumstances fit. Because in some instances you'll find the employer is one person and the employee is just one person. Exactly. So in order to have or to adhere to the basic tenets of natural justice, it is advisable that you maintain a record of everything that goes on. Have minutes detailing what the employer said, what the employee said, everything that happened, so that if a third party is later on involved in the process, you can go through the documents that you have, do the proceedings that there are or are availed to assess whether a reasonable man or a reasonable process, a good process, took place. Okay. Yes. So up to this point, I think we have explained how the process starts. Yes. We have explained what is to happen. After the employer hears the employee, the next thing is to make a decision. Yes. The decision has to be notified to has to be communicated to the employee. Now, the likely outcome, in my view, should be, I can think of 3 outcomes. First outcome is to acquit. To acquit is to say, having listened to you, we see no wrong here, so the dispute lies there. Okay. It has been resolved like that. Right. We have no case against you. Second, the employer might see there is something wrong here, but it does not meet the requirements of us parting ways. Okay. And the employer decides to give you a warning letter, which will go to your record. The third option, which is rather drastic, is for the employer to decide, we have found you guilty for the charge that was brought upon you, and we have to terminate the relationship. So at this point, any of these 3 has to be communicated to the employee within a reasonable time, so that the employee can know the next steps to take. Now, at this point also, the employee can say, I'm happy with the decision, or if he is unhappy with the decision that has been communicated, can decide to request for an appeal. So, in many of few words, that is the start and the finish of the disciplinary process.
Thank you very much. Now, in the case of an appeal, just like you said, some businesses are very small and there's just one employer. So when such an employee wants to have an appeal process, would they still go back to the same person that made the first decision?
Now, unfortunately, now in such a scenario, which becomes very tricky, I think it will not be an appeal per se, because an appeal is to someone else
Sure.
to consider. So perhaps if you see the grounds of asking
A
this
review?
particular person to do a review, you can bring your case forward to your employer to review.
Okay.
Yes. Now, maybe I need to mention that these are the basic requirements.
Okay.
They are as provided under the law.
Mm-hmm.
Most probably in this series we have discussed about an employment contract.
Yes.
Most employment contracts also provide a dispute resolution mechanism.
Mm-hmm.
And also if an union is involved,
Mm-hmm.
there has to be a collective bargaining agreement which provides for this, of how maybe these disputes are to be resolved. And also perhaps if there is a human resource manual also, or a disciplinary manual to provide for how this process is to be done. Or if it's a statutory body which is created in an act, the act will provide for these steps. So these are just the basic
Of a
minimums.
disciplinary
Yes.
process.
All you need to know is adhere to the rules of natural justice. Let it be fair, let it be open, and let it be transparent.
All right.
Yes.
So maybe just to wrap up the broadcast, if an employer, employers are people just like their employees, and they're open to having mood swings and not being very reasonable. So if an employer does not follow due process in terms of the disciplinary process, what are they looking at?
Okay. Thank you for that. Things will escalate, unfortunately, and the employer has the right to approach a court of law to have a look at all this process and see whether the employer has followed the process first of all, and whether they have a valid reason or a just reason to terminate the employee. Now, as you approach a court of law as an employee, you should know what you are expecting.
Okay.
First, you can ask the court to reinstate you. If your dispute is resolved within 3 years, you can be entitled to a reinstatement. However, in most cases, it's unlikely that the employee would like to go back to a place where there has been conflict.
Sure.
So they will be asking for compensation for the unfair termination. So your rights, or the rights, or the compensation that you can ask from the court is firstly 1 month's notice. If no notice was given to you, you are entitled to a maximum compensation of the equivalent of 12 months. Equivalent of 12 months compensation based on your gross pay. Remember, these 12 months are discretionary. A court can decide to give you 1 month, 6 months, 12 months, depending on the gravity of the situation at hand.
Okay.
And if there are any other pending terminal dues, you can be entitled, or you can ask for them. This, we have in mind things like outstanding leave pay, and perhaps any other entitlement that your employer is obligated to pay you.
All right.
Yes.
So viewers, I hope if you're an employer, I hope that you're able to understand what you need to go through if your employee is on the wrong. And if you're an employee and you've been called to the employer, or you've been given a letter to show cause, I hope now you're able to know what procedures you should go through and what is fair and what is not fair. Mr. Mugambi, thank you so much for coming to this broadcast today. Thank you, viewers, for watching. Please, if you like these videos, subscribe, share with your family and friends. We would like to thank Chigiti and Chigiti Advocates for their support and facilitating the shooting of this series. We would also like to thank our videography crew that is responsible for the camera work, for the editing, Mushiri Frames. We will have the email on this broadcast. And if the viewers want to reach out to you with queries about the issues we've discussed here, how can they reach you?
Thank you, Sian. I would prefer email contacts through my personal email, titusmogambimutua@gmail.com.
All right. And now if you have any queries for us, you can write to us at info@cyroglobal.com, info@cyroglobal.com, or you can also use our Gmail address, that's cyrologlobal@gmail.com. Take care of yourselves. Goodbye.